is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything.
So as long as she's attempting to take the test, continues to attempt to take the test, and then ultimately takes the test, that's not non-compliance. That's someone that's,
well, that's your,
for me,
that's your position. That's non-compliant.
Well,
it's really up to the court to decide whether somebody's compliant or not. With
you know what gets me? Stop it right there.
What you're saying is,
before we go on to it, it's clear to me she's never had one of these, okay? Because she needs to be educated as to how it works, how it operates, and how the probation department operates. So it's clear to me that this may be the first time she's had one of these issues.
Well, you're giving her a break. I'm not willing to give her. I don't know that for sure. I think that would be so weird that this is the first time.
Yeah, I know, but she's asking questions like she's dumb.
Well, there you go. Now that I'll buy. Dumb, I'll buy. First time, I don't know. It just sounds like, I think you were right before. She's going out of her way to find non-compliance, even if it means, whoa, what do you mean? The sun comes up in the day and goes down at night. You know, she's just pretending, I think, to not understand how this works so she can get where she wants to go.
Those situations you described is what you deem as appropriate to bring before the court.
it would, so I guess it would never be brought to court by way of a pretrial violation for an incomplete test with the information that I've talked about. So no, an incomplete test does not initiate a pretrial violation or from our end,
Right.
Because there are many reasons for a test to be incomplete. And there are circumstances where someone misses a test and then takes an on-demand test. That's not intentional non-compliance. And the goal is to test to ensure that the person's sober, and that's not, we don't deem that non-compliance. We never have, and we never would, in this case, initiate a pretrial violation proceeding based on an incomplete test that was subsequently passed. And so the schedule for her to be tested,
here we go,
is something that we discussed. Wasn't ordered by the court. The court ordered someone to be alcohol free.
What do you mean we discussed? So she knows when she's going to be tested?
With Ms. Fitzsimmons. I discussed with the defense counsel about creating a testing schedule, because it's more practical to have a schedule in place. There was no schedule that was ordered by the court. There's no frequency of testing that was ordered by the court.
It was
4 times a day, 3 times a day. None of that was ordered. She was ordered.
It was random screens. Excuse me, Ms. Officer January. It was random screens. Now you're telling me she's on a schedule to get tested? Is that what you're telling me?
We created a schedule, as we always do.
Okay.
As we always do. Not in this particular case. We always do.
It was random screens.
At least this guy, Mr. January, he's upstanding and he's honest and he answers her and he's not afraid of her and all. She's being a jackass, and quite frankly, the district attorney who's sitting right there and just like sitting there being useless as a piece of lint on a black dress, all right, is also, as far as I'm concerned, at fault here, along with the Commonwealth going to the court and objecting to Bradel's papers.
Yeah, but again, his name is James Gabatosi. Yeah, he's not good. And I know that it put him in a weird position. I get it. But, down deep, can't you just do the right thing?
Stand up to the judge, do the right thing.
But he couldn't, and he didn't. And so when the Commonwealth makes their opposition, which has such ridiculous lies in it, it makes it sound like he was jumping on top of the desk, objecting to what was happening, when we've heard what he really was or wasn't doing.
Screens anywhere in my materials, for the record.
Okay.
I don't know nothing about random screens.
Okay.
Judge, just so I can clarify that. When we get an order, someone's placed on pretrial conditions that include remain alcohol-free with scram testing, we always default to creating this testing schedule.
Okay.
And up to 4 times a day. So we'll schedule one for the morning, we'll schedule one for the mid-afternoon, we'll schedule one for the evening, and if we have to, we'll schedule one for later at night. And that's to ensure that sobriety throughout the day. In this particular case, we created a schedule for her to be tested at 9:30, 3 o'clock, and then at 8 o'clock. The only way we would not enter a schedule is if the court specifically said, I want the test to be done randomly. I don't want her to know when the tests are coming. And the test to be done randomly. And at that point in time, we would take her off a schedule, and then we would notify Elmo to be tested 4 times a day at random.
Okay.
So that's done on this case, and it's done on every case.
Okay. Attorney Bradle, do you have anything else to submit?
Judge, I would just offer, I respect and I heard Your Honor's take on the probation email, but for the record, I would move that into evidence as well. And I just want to also.
Commonwealth, do you have a position as to the admission of the email?
Well, I think we just heard with the email.
All right, so the email is excluded. Anything else, Attorney
No,
Bradle?
my objection, Your Honor.
Sure.
And Judge, I just want to state that on the pretrial conditions of release, it says comply with remote alcohol breath testing.
Okay. I don't know if that's what was ordered. I'm going to go back and listen to FTR.
I can tell the court from where I sit, I didn't remember any use.
I mean, you may very well be right, but I'm going to go listen.
Judge, I just want to clarify something. My email, and I know but it's important that the court knows, I didn't make a recommendation that scram condition be vacated. I never did that. I never suggested, it's all that email was.
Attorney, Officer January, nobody's asking you questions. Your testimony is complete. Are you asking to make a statement to the court?
If the court's under the belief that I recommended that condition be vacated or removed, then yeah.
I haven't said anything one way or the other, sir. We're here for one purpose and one purpose
Okay.
only, and that's
Thank
for the motion to vacate the scram device. So do you have anything else to submit, Attorney Bradle?
No, Your Honor.
Okay, Commonwealth, do you have anything?
No, I have no evidence to submit other than the arguments that I talked about, how important that the Commonwealth's belief is, in light of the court releasing the defendant, that testing be done.
Okay. Attorney Bradle, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that the material represented in the
The court is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it.
Okay.
Under the terms that are laid out in the affidavit.
So you're saying she can do it on her own terms?
With significant pain and dizziness and having to recover for several hours.
I understand what you're saying. It is certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest that
cover your
I
ass
think there's
statement.
other ways to do this. If the court wishes to have her tested for lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Torture.
Oh, okay.
But
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that The defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, you know, that there's probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that you would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go drink alcohol.
Okay.
That's not at all what this is about. So I just want to ask the court to consider any other alternatives that might not pose this type of an issue. Thank you.
Attorney Gubitosi or Attorney Moriarty, do you have anything to add?
No.
Okay, I'm going to leave the bench for a few minutes.
Your Honor, we're back on the.
Okay, so she does. She leaves for a few minutes to do whatever magic she's doing, talk to whomever she needs to talk to, and then comes back with this brilliance.
Record with the Fitzsimmons matter.
Okay, good afternoon, everybody. So I have reviewed everything again that's been submitted to me. And I will state for the record that Fitzsimmons has moved twice in a 3-day period to amend her conditions of release. On neither occasion has she submitted any medical evidence to support her claims. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community pursuant to General Laws Chapter 276, Section 58A2B. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary to ensure the safety of the community. After a thorough review of all of the arguments and submissions by the Commonwealth and Fitzsimmons, that conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the condition of being monitored by scram, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan and all other persons in the community. Accordingly, the court's prior order of release is vacated, and Fitzsimmons is ordered to be held without bail pursuant to Mass General Laws, Chapter 276, Section 58A.
Unbelievable.
And you could hear
Unbelievable.
You calling him over?
at the end, you could hear her crying.